Hi, everyone. My name is Dawn McCarty, and I am a volunteer with Erasing Families documentary. I will be conducting a series of interviews in collaboration with Michelle Jordan, another volunteer that I am working with to create a family healing and family court training resource for the Erasing Family Impact campaign. The purpose of the interviews is to let parents understand a little bit about how family court works, how that regardless of how great your case or evidence looks, the outcome may not be what is right or fair. It also is to show adult children who are alienated or estranged, who grew up choosing one of their parents while rejecting another, to understand the challenges that their family has faced in the adversarial system, or the system is not trained or set up to actually help families. Today I have with me Marc Garelick, who is an attorney in the state of California. He joins me today to help us understand the laws of California, so not everything he says may be the same in the state that you're actually listening from. So keep that in mind while you're listening. I'm going to bring him in now, and I want to wish him a very warm welcome. Thank you, Marc, for joining us today. Can you introduce yourself?
Sure. I am a family law attorney in Orange County, California. I am a partner with the firm Meyer, Olson, Lowy, and Myers. We deal specifically with contentious, high assets, and sophisticated family law litigation throughout California. We are part of the largest firm in California that does exclusively family law.
Wow.
I've been doing this for a little over 12 years at this point.
Oh, wow. Wow. So you have a really large law firm, but you're also in a very large state. So I'd like to get started on some of the questions that we have. And the first one is, what percentage of parents can actually afford legal representation in family court?
It's actually a very low percentage, and I can speak to kind of California in general. But just as far as legal representation goes, it's usually 15% to 20% can really afford representation. And I would say of that percentage, it's really only the 2 to 5% that can afford litigation in any format, and complex litigation even smaller than that. So there is certainly a pretty bad access to justice where we are right now, where most people can't afford the representation that they need.
That is very, very low, lower than I expected.
Yeah.
That's a very low percentage. So then what resources are available for them if they're going pro se?
There's a few resources that are available, and every county in California treats it differently, and likewise with every state. But in every county in California, you will find a self-help center, and the self-help center can help with basic forms such as domestic violence restraining orders, filing for a petition for a divorce or a paternity action. They can help you with basic requests for order for support and custody orders. And they also have the ability to refer you out to nonprofits. There is a few nonprofits in LA, the Harriet Buhai Center and the Bet Tzedek Legal Institute, which people can go to if they don't have the resources. However, both of those places are rather picky in what cases they will take, and they look to help the most needy in those situations. And then, you know, the other alternative is not litigation. It's either through mediation or some kind of mutual agreement or path between the parties, which is becoming more rare as time goes on. However, Orange County and LA County, and I believe San Diego County, so think of like very big cities and locations, yeah, generally offer free mediations and free settlement conferences. Attorneys like myself will volunteer a couple times a month and act as a mediator to help resolve those cases pro bono. So there's certainly lots of opportunity to do that. However, if there are certain types of facts in your case, like if you're a business owner or there is abuse or any type of situation where the two parties have a real big imbalance of either power or knowledge or even intelligence, it's generally a terrible way to go, because one party will absolutely take advantage of the other party.
Oh, wow. Yeah, and I get that question quite a bit out here. I'm in Florida, so one of the questions I get a lot is there anybody that offers pro se? And I think it really depends, and we have to figure out where do we send them. And and I think that in some states there's legal services with their and I don't know what else to call it other than the welfare department, which is the one I'm familiar with.
Right.
That they can go and ask for legal assistance. However, it might just be another resource for them to figure out what to do from that point. And I do know that attorneys dedicate some of their percentage of their time to help out with pro se litigants in their areas.
Right.
So this is great information. And I know you talked about California, but can you explain the difference between mediation and collaborative law and then litigation?
Sure. So mediation is a bit of a abused term, I think, because it's a very broad term. Specifically, and especially in California, mediation is looked at when there is one neutral, a third party neutral, and two parties, generally unrepresented, and the mediator acting as a neutral helps to mediate between a case.
Right.
If you have collaborative law, that generally is there's a team of neutrals. So it goes beyond a third party neutral, and you have a team, meaning you have a joint accountant, you have that third party lawyer neutral. Sometimes you have a joint custody mental health therapist, which is very helpful when there's custody issues. So you have a team, and that team kind of directs the parties as to how the case should progress and how it should be resolved. I generally tell people that both of those categories work really well in some situations and really poorly in other situations. And it's important to know if collaborative law is right for you or mediation is right for you. And again, kind of mediation is one of those things where if there's an imbalance in any way, financially, or just knowledge-based, mediation cannot be the right way, because one party is kind of not in the loop, and it's not the mediator's job to necessarily educate or advocate for that party. He or she is a neutral. So that can tend to lead to kind of the wrong conclusions or a resolution, but a resolution that's not going to stick. Collaborative law, on the other hand, there's a team there, so it's a little bit more broad-based, and that team does tend to kind of get everybody up to speed and gets rid of that knowledge or imbalance. However, that team is really going to direct you to a very specific resolution that they believe is appropriate. And that's not a resolution that's not necessarily advocating for one side or the other. It's a resolution that this professional team thinks is appropriate. So if it doesn't kind of feel right with what they're suggesting, it's really important to kind of get an outside opinion as to if that's really the right way, or if this is really the right type of solution-based resolution. And there's then multiple levels, so it kind of keeps on rising with levels. You then have where both parties are represented by their own counsel and they have their own advocates, but there is no third party neutral. And the idea is if both counsel can work together, they're advocating for their clients, they're telling their clients what's best interest, and they reach a compromise. And generally outside of mediation, that's the most efficient, fast way to get your case done and get a good resolution to your case. It takes away that imbalance. You have your own advocate, you are knowledge-based. It's generally a good way to move your case forward. After that, you have both attorneys and sometimes both accountants. And so each side will have their own expert, or instead of each side having their own expert, there will be a joint accountant. And the joint accountant will be responsible for, we generally call that person the court's expert, but they'll be responsible for creating an impartial report on the financial accounting issues. And then the lawyers know what to do with that and hopefully reach a compromise. or they each have their own accountants, and the accountants can speak their accounting language, and hopefully there's a resolution. And as you can see, the more professionals that you throw into the mix, generally the more expensive this is going to get.
Right.
So a joint accountant is definitely cheaper, and not to use the word in any bad way, but costs less money than each having your own forensic.
Right.
And then, kind of the final way, and really where you're ending up in cases that I am more involved with, is where everybody has their team of professionals and experts, whether it's your lawyers, your accountants, your appraisers, your evaluators, and your custody experts. Both sides have those teams, and then you rely on a private judge to help mediate and help come to a solution based on a complicated case.
Right.
And then that private judge can say, hey, if I was your sitting judge in court, this is what I would order. This is what I think if you hit it out of the ballpark would be, and then this is what I think if they hit it out of the ballpark would be. And most complex cases, or most cases with a lot of contention, resolve in that manner. And if all else fails, you're in the public court system and you're stuck, on the waiting of time and appearing at multiple hearings, and at the whim of all of the cases that are on calendar in that courtroom for that day. So the most expensive option is always to go to court. Even if you just have your own attorney and they have your own attorney, that's going to be more expensive than having a private judge come in and help resolve your case, because it's just the way our court systems work. And especially within the last 6 months, it's gotten much, much worse. The delays have tripled. The amount of filings have gone through the roof. The amount of contention has gone through the roof. So it's the last thing that anybody wants.
Well, and it sounds like there's no cookie cutter way of choosing, I'm going to just go to mediation, I'm just going to do collaborative law, or I'm just going to litigate. There's really different levels, and it really depends on the circumstances. So people really need to do some homework before they make this decision. Sounds like mediation would be your non-conflict type of solution. And then if there is some conflict, but starting off with, or there's a little bit more than you would take to mediation, that little bit of conflict, you might want to move into the collaborative law and then go through those levels depending on the level of conflict. And then of course the high conflicts would end up in litigation more than likely anyway. Does that sound right?
That sounds certainly, but what I would tell you is mediation and collaborative law really start off on the same pathway. It's rare to see someone go from mediation to collaborative law to litigation.
Okay.
Usually it's mediation to litigation or collaborative law to litigation, just because there are benefits to both and positives to both, and not necessarily one outweighs the other. It's really just kind of a case-by-case basis and a factual situation if one's better for you or not. Mm-hmm. And really just kind of the sophistication of what the issues are. Are there property issues involved? Is there compensation issues involved? Are there custody issues involved?
Okay.
All of those are going to play into it. There's a lot of strong presumptions in most states, but particularly in California, that custody should be frequent and continuous contact with both parents. And what that has essentially come to mean is that equal or as close to equal time as possible with both parents.
Exactly.
There are a million reasons why they should not be equal or close to equal time with both parents. However, the court doesn't look at a million reasons. The court's going to see, is there domestic violence? Is that parent absent from one parent's life?
Yeah.
What is the status quo? Are there drugs and alcohol involved? And if you really don't have those things going on, it's ridiculous to fight over equal custody time.
Exactly.
It's a waste of time for everybody.
So your practice is mostly in family law. And so when would you advise or suggest that people wouldn't need your services?
Sure. So most people don't need my services who are going through a divorce. I mean, that's the honest truth. I'm not in the business of taking people's money who don't need litigation. So when it becomes, and usually the litmus test, I can ask someone right off the bat, are both of you W-2 employees? I can tell you right away, 9 times out of 10, you probably will not need the services of the big bad litigation firm. You're going to want to look towards mediation because your financial issues won't be complicated, and it's something that you should be able to resolve. It's when you start to have an owner of a business, or there are move away issues where one parent wants to move to Florida, the other parent's living in California, and what are the reasons that they're moving, and what is that how is that going to impact the children? If there is domestic violence involved, and when I say domestic violence, I think a lot of people abuse the Domestic Violence Prevention Act in California. And then there are a lot of people who really need the protection that it holds.
Well, are judges trained to be able to spot that and other personality disorders like complex trauma in a parent? Are they trained for that?
So the answer is generally no. And don't expect your judge to ever be educated on personality disorders, or most judges understand that there is a cycle of domestic violence, but beyond that, kind of what creates the domestic violence and the difficulty in getting out of it, they're not as educated as you would want them to be. And so it's super important, and part of what I do is make sure that my judge is educated, make sure my judge really understands what personality disorders are and how it impacts a case.
Would they be trained in child attachment system? Do they understand that piece?
So you'll see judges that have been around longer than others who will get it. And eventually some attorney will come along and really educate them, and it'll click. And then you'll see a lot of newer judges who have been in the family court for a year or two who just haven't gotten there yet. And it's a hard thing to prove and show. If there is alienation, or if there is attachment, or if there are legitimate reasons why a child doesn't want to be with the other parent. It's a lot of nuances. And if you're new to family law, or if you are a new family law judge, you can almost bet that they're not going to get the intricacies of what's going on there.
And how about if they have too many cases? Like they might be a seasoned judge, but they have too many cases. Does that have an impact as well?
In my experience, not as much. The judges who get it, and will make the appropriate orders and do what they can. But there is certainly a point in time, I believe, that once alienation has really taken a strong hold and a child reaches a certain age, like preteen, teen, it becomes a losing battle to fight back. And there are things that you can do to stop it, but it takes a monumental effort, because you're not just changing your ex's or baby mama's opinion, you're changing that child's opinion and the child's perceptions, which is, especially for a teenager, is a much more difficult task.
And so how does the court address contempt of court issues when one parent is blocking the other parent, or they're not complying with visitation orders? How does that work in California? It probably is similar with other states as well. So I'm going to let you talk on California if you'd like.
Certainly. So a court is always looking out for the best interest of the child. And that is a very overriding principle in all our family law courts. So at first blush, it becomes obvious to at least the person who is being alienated from, hey, it's not in the best interest of my child to be alienated from me. I should be in their life. I should be part of their life. This is not fair. And a court's going to say, okay, your remedy, if you're not exchanging the child, or if the child doesn't want you to come with you, is to call the police or file a contempt action. But I can tell you from experience that no police officer is going to throw a child over their shoulder, drag them out of their house, and put them in the other parent's car. They're going to say, go to court, or do something with court. And so generally, what courts will do is not necessarily put somebody in custody jail, but there will be admonishments, and then there will be kind of measures put in place and conditions, such as therapy, or reunification therapy, or family therapy. And then in extreme cases where a parent is still fighting it and not taking their child to the therapy, and nothing is improving, the court could make a drastic change. And I've seen courts take custody away from a parent completely, because it's not even sanctions, it's take away the child from that parent because they are not acting in the best interest of the child.
Right.
I've seen, and it's happened now 3 times in my career, where a judge has ordered that the child go to a camp and be away from the parent that's doing the alienation, so that that child can build a relationship with the other parent, and they'll go, to the river and hiking and in the wilderness, and try and recreate that bond, kind of as a last ditch effort to try and do that. And a judge can make all the orders until they're blue in the face, but at the end of the day, if that harm to that child and that relationship is irreparable and can't be repaired, there's nothing anybody can do. It's done. And I usually tell my clients when I think it gets to that point, wait until that child is a little bit more mature. You're not going to do anything now. You're going to spend thousands and thousands of dollars trying to go after them. Once they're 18, 19, 20 and living on their own, and they have a little bit more of a mature attitude and have moved away from home, they're going to be much more willing to enter a relationship with you than when they're 15 years old, and you've gone through all of these things with the court system and nothing is working.
Yeah, and that age group is difficult anyway, just without this added to it. So there's that to be to consider as well. So how often would a court sanction one of the parents that don't comply?
So as far as monetarily, it's actually very rare. I would say it's rare to see monetary sanctions, meaning, you didn't do the custody exchange, you have to pay the other side $5,000 for their lawyer fees. It's generally done in other ways, like I'm finding you responsible for alienation, therefore you're paying for 100% of the co-parenting therapy, reunification therapy for the child, and make a financial burden in some other way for them so that they are more willing to cooperate. And truthfully, that's a much better avenue to go for a parent who has been alienated, is to say, I don't want money from you. I want this money to go towards repairing my relationship with my child.
Yes, yeah. And I think that the children would benefit from that as well. Less conflict. So can an attorney request that a court build in a consequence to the parenting plan that doesn't require the parent to wait for several contempt issues? Sometimes it's drawn out. Can they do that sooner rather than later, and file a change of circumstance?
Yeah, I mean, the answer is yes. You need to be a little bit creative about it, and it really will need to apply to both parties. So it can't just be kind of like a unilateral, if you don't comply with this order, then you're going to be punished. It has to be if both parties don't comply with the order, then the consequence applies to both parties. And if you can make kind of fair and balanced, and I don't necessarily call them consequences in any agreement, I'll call them conditions. And you create these conditions, and they essentially become roadblocks. So if a parent starts to go down that path, they hit that roadblock. And you want it to be self-executing. And most attorneys are either not going to think about the conditions and put them in there, or are not going to foresee that kind of what if scenario when they're drafting their agreement. Because the idea is generally if you're reaching an agreement, then that doesn't exist and you're hoping everything moving forward is going to go well. And likewise for a court, if the court doesn't see it as a high conflict case and a contentious case, the court's not necessarily going to put those conditions into any order that it makes.
Okay. Well, how about we have a lot of situations where they call it the silver bullet, where one of the parents is allegedly accused of physical abuse or any kind of abuse against the other parent or the child, and it's actually used to gain an upper hand in the case. So is there any recourse for that parent that's being falsely accused to have this domestic violence order heard in a criminal court instead of the family court?
So a lot of points to that. So generally, and the way that I tell people to look at it is they're using the Domestic Violence Prevention Act as a sword instead of a shield. Okay, so you'll hear this saying where they have a sword, and instead of using it as protection with a shield, they're using it as a sword as some kind of tactic. And usually they're doing that for one of two reasons. The first being that they want that party kicked out of a residence. So they are going to make up whatever claim they need to make up, because in California, and frankly in most community property states, the only way to get a party to move out of a family residence involuntarily is through a domestic violence restraining order. And so if mom has consulted with a lawyer and knows that that is the only reason, they're much more likely to bang their head against the wall and claim that it's domestic violence than someone who doesn't know that, or someone who moves out of a house voluntarily. And the other reason is just kind of what you were saying, and it's for custody. Because if you do have a restraining order, there is a presumption that the protected party should have full legal and physical custody of the children. And so many people use that opportunity to say, hey, this is really my only chance where it's not going to be stuck in some equal custody agreement. I'm going to come up with a bunch of nonsense and create, these claims of domestic violence. It's a tough situation, and I see it far too often.
Right.
The only way to really protect yourself is to document, to have text messages back and forth between you and your spouse. Show that your spouse is not in fear of you and has communicated with you and has questions to you, and will continue to contact you through whatever period they claim there is violence. To get collateral witnesses, so teachers, extracurricular, even
build your case.
Family members. Show this court that that's not who you are, that it's impossible for that to have happened, and that the real motive is something completely different. And I just had a case a couple months ago, and there was this picture, and the picture was of the family, smiling faces with the kids, everybody kind of hugging. And that incident happened on the day that the domestic violence happened, where this woman said that she was in fear of her life and needed full custody of these kids. And it just absolutely destroyed her credibility with the court, because it's difficult to go from a leap of smiling, happy, laughing in a picture to, doom and gloom of domestic violence, fear for my life within an hour or two.
Right.
And, whatever it's going to be, and text messages, that's really going to be the most important thing. And whatever that person does who is being accused of this stuff, the worst thing that they can do is add fuel to the fire. Don't violate the temporary restraining order. Start taking a class right away on co-parenting. Start going to therapy right away. Show the court that you are going to kind of take away those conditions that I was talking about earlier that the court might put in your way, and knock them out of the way and say, hey, Your Honor, I've already done all of these things, just proactively, voluntarily, because I want to be a better person, and I want to show the court that that's not who I am, and this isn't true.
Right. So this is working up into building a case and going either into mediation, collaboration, or litigation. So let's bring in the role of the forensic psychologist at this point. Who do they work for, and who are they a witness for?
Right. So there's lots of different roles. And I try to stay away from the word forensic psychologist, because that's generally a very specific role that a mental health professional will play in a divorce action or a family law paternity action. So kind of first you have to look at the different roles. So there is the child therapist, and that's the therapist who is going to the child is their client. They're going to be acting in the best interest of that therapist or that child. Generally, you want that therapy to be confidential, meaning that it doesn't bleed into the action. You want it to be a safe space for that child where they don't have to worry about their parents learning about it. You kind of step up and you have the family therapist. The family therapist is generally someone who is not confidential, and will meet with everybody in the family and kind of work on kind of this family. The family bond, right? Right. And then you have the co-parenting therapist. The co-parenting therapist generally will work with one party individually of how to work with a parent to either co-parent or parallel parent, which is basically when parties can't work together, but they can at least be on parallel paths and ideas with the child. And they'll work with one party or the other party, and sometimes work with both to bring them together to try and resolve whatever issues are. However, I only necessarily see that in the low conflict cases. You don't see that in high conflict cases. Then you kind of move into the court world of what that mental health professional would do. So at the very low level, we have something called emergency investigations. Sometimes you'll see it as an EI or a CCI, a child custody investigation. Generally, these are very quick interviews done by a social worker. And they're 1, 2, 3 days of interviews where the social worker is kind of getting an idea of what's going on in the household, what's going on in the family, and they're more of like a news reporter to the court. They're not there necessarily to analyze what's going on in the family. They're just there to say, this is what's going on in the family, this is what the children say, this is what dad says, this is what mom says, this is what it looks like at the household, and report to the court. And then you have, this child custody evaluation. And it can be a limited scope, meaning that the investigator is really only there to look at one issue, like move away or school selection, or, what I've seen, should the kid be bar mitzvahed or not? I mean, there are lots of limited scope issues that can occur with an evaluation. And then you have the general kind of broad scope evaluation. Then it's that 730, it's pursuant to a California code, so you'll hear the word 730 a lot, and I think you actually hear it in other states as well. But they're the court's expert again. So just like that joint accountant is the court's expert, this evaluator is the court's expert. So he's not there to advocate for one side or the other. He has a certain allegiance to make sure that whatever the court does is in the best interest of the children. And they're going to do a rather intrusive process where they interview the kids separately with each parent. They interview the parents. They interview all of the collaterals, the teachers, the priests, the coaches, the new girlfriends and new spouses, the grandparents, and then they make everybody do psychological testing. They are supposed to do some or form some hypotheses in their mind as to what's going on. Then do further exploration as to what's going on, and sometimes that's a home visit. Sometimes it's going to a soccer game, and then after that they'll do some analysis and create a big report that's usually submitted right into evidence, and the court's going to consider that.
So is there ever a diagnosis or a treatment plan that they recommend for the entire family?
Yeah, so they're not supposed to make a diagnosis, but they do make recommendations to the court, which would include therapy or co-parenting therapy, perhaps how to work a soccer game where one parent's on one side of the field, the other parent's on the other side of the field, and they'll make recommendations to the court. Once that evaluation is done, and let's say this evaluation happened and it was really unfair and the evaluator just didn't get it, you have the opportunity to hire a 733 expert. Okay, and that's another mental health professional. That professional is now your consultant, your expert, and their job is not to meet with you or the kids, but to look at the report and say, the evaluator did this, this, and this wrong. The evaluator didn't give enough weight to this issue or take the time to do this, and therefore the court shouldn't consider the recommendations. Okay. And you're pretty deep into it when you get there.
Right. So do they need experience in the complex trauma, the attachment, the family systems, or that personality disorder pathology? Are they required to have that experience?
Every state has different requirements to that. California in particular has a very lengthy statute about all of the requirements. I have found that generally they all are very aware of all of those issues. They're very aware of alienation. They're very aware of false accusations, of personality disorders, of all of those things. I mean, these 730s are generally PhDs who that's all they do are these custody evaluations, and and they get it. It's the social workers. It's kind of a few steps before that. You get to that person where they may not be educated in that.
And are they relying on their report then, or do they go beyond that?
If it gets to that point. So if there's no 730 evaluation done, you really have nothing to rely on. You weren't able to either afford it or engage with that person. And so it's kind of the litigant's job to really educate that person, including the social worker. And I've seen pamphlets given to social workers. I've myself given, and I like to usually put together like an organized notebook for the social worker and say, here's all the evidence, here are the pictures, here are the pleadings, here is who we believe you should talk to. And by the way, here is a little article on parental alienation.
So it's really important to have that, an attorney that has that knowledge and that understanding to that degree. Okay.
Absolutely. I mean, it's crucial. Yeah.
Can a parent refuse this evaluation, the 730 evaluation? Is there a point that it's not a well, let me rephrase that. Can they refuse the evaluation? And if there is not a point that it's there's no diagnosis or treatment for that entire family, without the parent appearing to be not like as if they're not in the best interest of the child in the eyes of the court.
Absolutely. So kind of different phases here of how this happens. So at the very beginning, either the lawyers or the litigants are going to say, hey, there's a high conflict custody issues here. And one side's going to say, well, I propose that we do a 730 evaluation and get to the bottom of it. And the other side may be like, hey, wait a minute, that's a really intrusive, expensive process. We don't need that. Okay. So if there's no agreement, then the side that wants it needs to file a motion with the court and say, hey, Your Honor, I believe this is appropriate. And the other side has an opportunity to say, no, it's not appropriate. Again, you know, a lot of discretion up to the judge, and a lot of it's going to depend on what judge that you get and how educated and experienced they are. The most veteran judges are going to say, you're right, we really don't need a 730 evaluation. I know exactly what the 730 evaluator is going to say and do. Let's just, you know, put on your case. And let's talk about custody, and let's go straight to the witnesses, and let put those collaterals on the stand and let me take their credibility. But you know, they still happen, and there is still a reason to have a 730 evaluation, and there are good reasons to have it. So let's just say that the judge orders it anyway. Okay. And you're in the process. There's not a whole lot that you can do to stop the process once it starts. So that evaluator is going to make his recommendations, is going to draft his report, and you're going to get to that point where then if you don't agree with those recommendations, you're going to have to decide if you are going to fight it in court, because they're just recommendations, they're not orders. The evaluator is not a judge, and don't let him think that he is. He's just a mental health professional who's trained to give recommendations to the court. If you don't agree with those recommendations, you have every right to fight it with or without a 733 expert. And you can say, this isn't right, and you know, what they're saying is not true. And in litigation, especially in high stakes litigation, the most telling component of that is if you don't agree with the recommendations of the evaluator, you can decide to depose that evaluator. And so someone like me will have them come to my office. I'll sit them in my office with a court reporter and maybe videotape it. And I'll start asking them questions about their process, about their hypotheses, and about what if scenarios. Like, you know, if this fact isn't true, would that change your recommendations? And if you can get that evaluator to flip and change their mind in the deposition, their evaluation is going to be worthless, and everyone's going to know it. Because at that point, they've just kind of changed their mind, and their recommendations now are up in the air, because there are facts that may or may not be true, and depending on if those facts are true or not, changes their recommendations. So
well, how about the clinical psychologist? You know, are their reports, how does the court review their reports?
Certainly. So you generally don't see reports in the sense of like an evaluation. You'll see letters. And so the therapist will, you know, let's just say it's a co-parenting therapist. They'll issue a letter and they'll send it to the attorneys and to the court. And they'll say, hey, I believe, you know, so-and-so child should continue with therapy for 6 months, or so-and-so dad should not be allowed to go to the soccer events because of the conflict that's being created because of it. And that will then go to the court as kind of a letter and almost as a piece of evidence. Generally, once judges get that, they'll either set their own hearing date to decide what to do with that, or they'll make a request for one party to file a motion if they want that letter to become the orders of the court. And then you call that therapist and you bring him on the stand to court and you ask him questions about that letter and what reasons did he get to reach those conclusions and make those recommendations to the court.
Okay. So moving on to what are the mandatory requirements regarding the evidence of child psychological abuse, if any?
So, so you want to know what the court must consider in looking at child abuse?
Yeah, what are the mandatory requirements for reporting child psychological abuse?
Right. So in California, we have mandatory reporters, and there's a whole host of them, like teachers and
Guardian ad litems and yeah.
Exactly, and parents, coaches, therapists, any of those. So what happens when one of those mandatory reporters will report something, and they'll say, hey, I have a concern, I believe there's some abuse going on. In California, it'll go to the Child Protective Services Department.
Do they view psychological abuse as abuse as well?
They do. So it's psychological, it's emotional, it's physical, and it's also financial.
Okay, good.
So if someone is being financially abused, that is a reason for a mandatory reporter to report the abuse. And you know, I've actually seen it where a dad says, "I'm not giving you dinner unless you do these 2 chores, and then the $10 that you get for doing those chores will pay for your dinner." That's abuse, and that's something that should be reported. So once that's reported, Child Protective Services will get involved. They will do their own investigation. Child Protective Services is, again, Masters of Social Work type level mental health professionals. They're generally not PhDs or PsyDs or marriage and family therapist credentials. So you'll see the social work with that. They'll get involved in the case. They will issue a report, and the report is either going to make a finding of abuse, be inconclusive, or it's going to be unsubstantiated. If the claim is against you, obviously unsubstantiated is the best thing that you can get, but I would say 90% of all reports are inconclusive. And it's basically the social worker doesn't know if it's true or not and couldn't tell the court.
Right.
And that's going to lead to all of the other things that we talked about, a custody evaluation, whatever it's going to be. If a Child Protective Services social worker has a finding of abuse and believes that abuse is occurring, they can and normally do report that to the district attorney's office. So if that social worker believes that abuse is going on, it's going to go right into the criminal world, especially if it's severe abuse. And the child could be taken away from both parents and put in foster care. The DA could make arrests of one parent or the other parent. And it also gives an opportunity for the family law attorneys to go into court on an emergency basis and take custody away from that other parent immediately.
Well, that was my next question, is how does that work in temporary separation orders, you know, in order to stabilize a parent?
Right. So, so it's rare that you see the court do it on its own motion. Generally, it's got to be a parent going in there saying, hey, Child Protective Services was called, the report was either inconclusive or there was a finding, and these kids need to be taken away from this parent for a temporary period of time. And if there's enough evidence, and you know, it's all in the pleadings at that point, if there is enough evidence there that there's a true emergency, the court will take the kids away from that father and set an evidentiary hearing. And that evidentiary hearing can occur, or it's supposed to occur within 3 weeks, but
so they're more expedient?
They're supposed to be, but the reality is that they get continued like everything else.
With the volume, especially nowadays.
Right. So a parent could be without, you know, there could be false allegations that are made, and the social worker kind of buys into it, and the kids get taken away from a parent, and that parent be away from that child for a long period of time. I've seen 6 months, 8 months, a year where you just couldn't get to the hearing to get there, where the judge could order it back. And when it's that long of a period of time, you can't just throw the kids back into that situation. They need reunification therapy, and they need to kind of slowly integrate back with the other parent. It's not just going to be boom, everything goes away. So it can be a very long, drawn out process. It's a very sad process, and it's a hard process to stomach. You know, one of those situations is don't go through that whole process without an attorney. You will never see your kids again. The odds are stacked against you. There is every reason to have someone who's going to be able to advocate, to understand what the issues are and how to help you get through it, so you know what your end goal is and the steps that are involved to get there. Otherwise, you're just going to get lost in the continuation and the cycle. And then, once, if there is false abuse, and then that gets compounded by alienation, it just immediately sets you down a path where it's very impossible to recover from.
Well, and how can the courts participate or assist a parent being the best parent they can be, rather than the courts helping to choose which parent would be the better parent? Can we move away from that and into helping parents become the best parents they can be?
Yeah, I wish. Our court systems are not set up to look at it in that vein. And really the only kind of tool that a judge is going to have is that therapy tool. And you need to use it aggressively, because if that therapy condition is not working out, you have an expert who's going to tell the court it's not working out and this is why, or you'll have an expert say, mom is alienating dad and this is why. These are what the kids are telling me. Mom is talking about the case with the kids. And without that, you're not going to get the court to be able to do a more drastic measure, such as take the kids away from the other parent to stop it.
Yeah. So how would it be best, or how have you, maybe even with your practice, transformed your practice so that we can reduce the winner versus loser scenario?
So I personally feel like there are a ton of ways to do that and reduce the contention. Number one, there needs to be consequences for people who are going to make the wrongful contentions. And those consequences needed to be stated up front. So you need to tell that person, you need to tell that attorney, this is not accurate, this is why, here is the evidence, and there will be these consequences if you continue down that path. Generally, people with personality disorders only will respond, especially in a family law setting, to consequences. So if you're in that dynamic and there are no consequences, there's nothing to stop that person from continuing to go on and continue to do what they do. A lot of it is going to depend on who that other side hires. So you want to work with that attorney and figure out some kind of solution. And even if it's a long-term solution where it's not going to get your client immediate equal custody time, but it's a step-up plan with these conditions that you know and you can put in front of your client that are tangible, that he can follow, you get around that contention and you reduce it. Because the second there is a solution and it's on paper, everyone magically starts to behave a little better because there's a path. Everybody knows what they're supposed to do. Everybody knows what their role is. Mom always knows that if she doesn't take the kid to therapy at 5 o'clock, dad's going to be sending her an email, and that's going to be followed up by an email from the attorney, and it's going to turn into a mess where she's going to have to incur, or he's going to have to incur, a lot of fees. Yeah.
So thinking about this from the child's perspective, do you believe that the judges and the evaluators are aware that children are often absorbing and feeling the trauma and the emotions of the conflict from the adults, first of all, and that the children are not going to just grow up and grow out of or get over the trauma without some kind of help themselves?
Yeah, I actually believe that's the one thing the judges do get.
Okay.
And it's very well known within the family law world that if there is conflict between the parents, it will affect your children.
So then the children are going to need their own therapy, their own set of resources and tools for going through a divorce with their parents.
Absolutely, and there are more tools than what we've even talked about for those children.
Right.
One of them is minors counsel. So the court can say, all I hear is he said, she said, and I want to know what's going on with these kids, and I'm going to give them their own attorney. And it's good and bad. Minors counsel has a lot of power and authority, and if a kid is truly aligned and alienated with one parent, it's going to feel like it's 2 against 1 with the minors counsel.
And it's really hard to break through and get the truth out of that child at that point.
That's right.
Yeah.
So it's a double-edged sword, but at the same time, that minors counsel could acknowledge that, hey, dad's a good dad and just wants to spend time with his kids.
And sometimes that's what they really need. They need to hear those positive words about their parents rather than what they're seeing and living through, to have that alternative come through. Do you think that anybody going through a conflict divorce like this should be required to watch the Erasing Family film?
Yeah, I actually do. So knowledge is power, especially in a family law action. The more that you know kind of all of these issues that you're going to face, the better prepared you are to face them, and to even interact with your own counsel. So the more information you can get and kind of bring in, and it's almost like a vocabulary thing and an understanding. You may never have heard of the word alienation before, or you may
Right.
never have heard of alignment before. All of those are crucial things for you to understand, and not just on like a peripheral level. You need to know the
Yeah.
words that you need to use with your kids. You need to know the track that you need to go down legally, whether it's mediation or through the court. And the more information that you can get and bring in, the better off you're going to be, and be prepared for kind of what's to come.
Yeah, I think that's absolutely important because with the people that I speak to, a lot of them say, I didn't know what this was until I started going through a divorce myself. So it's not even heard of until you're in the thick of it. And then at that point, it could be where it's already happened. So now what? Now you're behind the game, and you're playing catch up, trying to level that playing field somehow. So that being said, would it be advisable and valuable for the professionals, mental health professionals, anybody that's a friend of the court, in the courts, to also watch this Erasing Family film?
Yeah, I mean, again, absolutely. I kind of touched on it a little earlier, but education
Yeah.
is really critical,
Yeah.
especially for all of these professionals. So it's the social workers, it's the mental health professionals, it's the lawyers, it's the judges, it's even the clerks. Everybody needs to kind of be educated as to what these issues are, what they look like, what real alienation looks like, what real alignment looks like, what real abuse looks like.
Yeah.
Because if they're not, and someone comes in and writes this declaration with all kinds of things in it, you're more likely to believe that than you are not to believe that. And it's important to be able to identify that, hey, wait a minute, she's
I know
talking
this
about this to
behavior.
the kid, or she's saying something about the kid. And once you are educated, and you can recognize that behavior, you're much better at
Yeah.
performing with whatever you need to perform, whether for your client or for the court or for the people, whatever it might be.
Well, and I think when everybody has the same thought on their minds as they enter a courtroom or enter into their attorney's offices, that they all are aware in that knowledge, like you're saying, I think that's valuable for everybody to have that, being on that same page will definitely make a big difference. So what is it that you can do to help Erasing Family be presented to your legal contacts, as many as possible?
Yeah, I mean, I've been talking about erasing families for a little while now with some of my colleagues, but I think that it's important for erasing families to be able to present to places where these professionals converge and meet and talk. So bar associations, networking groups, anything where you're going to see a convergence of experts and professionals who deal with these issues. This needs to be there, and they need to have and talk about these subjects, and this needs to be presented to them.
Yeah, is there any way to make this parental alienation illegal? Because I think it's just passed in Puerto Rico that it is illegal to alienate another parent against or from the child. Is there any way we can bring that to the States?
Yeah, it's always, I think, part of the consequences. So how we look at what those consequences are. So when we say something is illegal, you're assuming some kind of penalty is tied to it. And it's what is that penalty, right? So if you're found to have alienated a child from a parent, what does that actually mean? And I don't know if it needs to be statutory, which I think it would be helpful, and if it needs to be penal code or in the family code. But there should be some kind of finding, just like there is in domestic violence, that if there is a finding of alienation, there should be presumptions that come into play. Number one, that you're not fit to be a parent, and number two, whatever other consequence would be appropriate, monetarily or extracurricular activities or decision making in legal custody. All of those could be codified or considered by courts, and then they would be able to be used much more effectively.
Yeah. Well, thank you. Thank you so much for all of that very detailed information. Is there anything else that you would like to add to any of these questions?
No, the only thing that I would add is be very wise with how you pick your attorney and how you pick your professionals. You get what you pay for. There are a lot of people in this field who say that they're family law attorneys or they're experts in this realm, and they're really not. And you need to be able to interview them. You need to take the time to find the right one whose personality is going to mesh with your own, who you can trust, and who you can use to help guide you through the process. I can't tell you how many times someone has come into my office and wanted to retain me, and I said, I am not the right guy for you. You need to find
Yeah.
someone else who is going to help you with these things, and it's important to make that distinction.
Mhm. I agree. I think that we need to be able to take in some questions ahead of time and interview the attorneys. I think that mutual interview, like you're saying, are you the right guy to help them with their case? So I think there does need to be a better path or better understanding that just because you went to one attorney or you stopped at one mental health expert doesn't mean that's the one that is you have to go with. You need to make sure that it works works for you. So that's great advice. So with that, I think we got enough questions out of you. Thank you so much for spending I just want to honor your time, and we're at the bottom of the hour now. So thanks again so much for joining me today. And it was great talking to you and great to get to know you a little bit. If you have any questions, you can reach out to Michelle or myself. And at that, I think that's all I'd have for now.
Nice to speak with you. Thank you.
Thank you so much. All right.
Take care.
Bye-bye.